Now, I did want to get on the show here tonight and tell you guys Aaron had called me from the jail. I was his only phone call. He's like, Sean, the Somali bulls are back there. I can hear them banging on the bars. Help me. Put money on my commissary. But Aaron decided to go on Kevin Brennan's show, so that kind of ruined the idea that Aaron was in jail. But I was hoping to do that, and I thought it would be hilarious. So let's see what happened to Aaron. It's pretty basic, but we're just going to go through it, chat, because we need to go through it together. We can law-splain this, and we can law-splain this via the interwebs. It's almost like I could use it as a saying. I'll have to see if some. I don't think anybody else has ever used that before. So anyways, it's a petition to enter a plea of guilty in a felony, which obviously felonies are bad, chat. That's the bad thing. Or a gross misdemeanor, which isn't good, but it's a lot less bad than a felony. And with the gross misdemeanor, you face up to 1 year in jail. This was filed today, April 10th, 2035. See, chat, that's how good Aaron is. Aaron's cucking his way into the future. That's how good he is. The Steel Toe Time Travel Show is what we're dealing with. So you have Aaron Imholte, and he says, I'm a defendant in the above entitled action. I do respectfully represent and state as follows. My full name is Aaron Imholte. I am 38 years old. My date of birth is 12/24/86. The last grade I went through in school is 2 years of college. Now, why do they go through all of this? Well, they're going through this to establish that Aaron is an adult, that he's over the age of 18, that he can establish his age and he can tell you his birthday, because that's how you establish he's competent at this point, that he's been through 2 years of college. And what does that show? Well, that shows that he is fluent in the English language. He has some level of reading comprehension. And that is critical because theoretically on a plea, he could raise things like, I'm so retarded, I don't know what day it is. I don't know my birthday. I'm illiterate. Any number of things, which, you know, he might, when he has to, any number of things that might happen out there, he could try to raise. These prevent that from happening. He says, if filed on my case, and that means sometimes it might not be filed if he's pleading out right away and there's an agreement to things, I have received, read, and discussed a copy of the complaint. I understand the charges that have been made against me in this case. And this is specifically, I've been charged with the crimes of non-consensual dissemination of private sexual images, a felony. And they also got charged with the gross misdemeanor version. So yeah, some of you are saying, is this kind of what Destiny's facing? Remember, Destiny's only facing a civil suit, which is where I think that should belong. And this one shouldn't have been charged, but it got charged anyway. And, you know, that's what happens when people run around and go crying to the police, you know, and play the game of telephone, as they also phrase at times. So remember, you can't trust the cops. They probably lied. And they force people to lie all the time and all kinds of bad stuff about the cops. I'm just saying, that's what people have said. This was committed on or about May 27th in Stearns County, Minnesota. He says, I am represented by an attorney whose name is Todd Peterson. So he's showing that I have had access to counsel. I've had sufficient time to discuss my case with the attorney. I'm satisfied my attorney has fully informed me of the facts. My attorney discussed possible defenses to the crime I might have. I'm satisfied my attorney has represented my interests and has fully advised me. This prevents him from coming back and saying, oh, my lawyer for me, he didn't tell me anything. So that is what we're doing here. He's saying, I've never been to a patient in a mental hospital. Why? Because that way there's no issues of competency. He can't say, look, I'm crazy. You can't trust me. And then he says, and guys, I think some of you are saying, what am I saying about both of them having felonies? Remember, I'm saying it shouldn't have been a felony, and Aaron shouldn't have been charged at all. Just like Destiny, like criminal charges are not necessary. They shouldn't be filed. There's a civil suit. Go ahead and get that civil suit going. Brew that up. Just like Aaron, if that was really going to be something, so like getting the government involved like this, kind of gay. Kind of gay. Pretty gay. Pretty gay. He says, I have not been ill recently. Now, this doesn't mean mentally ill. This just means the issue of, you know, was I sick? Was it like I am in a lot of pain? I can't think straight. All the issues like that. I've also not talked with or been treated by a psychiatrist or other person for a nervous or mental condition. Now, if he had been, the court will sit down with him and say, okay, you're meeting a psychiatrist. What is your problem? What are we talking about? What does this do for you? Can you think straight? Can you think clearly? Maybe we need to have a competency evaluation. What were you hospitalized with in the mental hospital? How long ago was it? Is that clear it's not affecting you anymore? Those are all things that have to be addressed if he does say he has. And that would probably be at length on the record. He says, I have not recently been taking pills or other medicines. Now, this shows that he is not taking any medications that would affect his judgment or his ability to think clearly. Now, it's funny because when you go to court sometimes with somebody and they're like, on any medication, and they're like, yeah, I take Claritin. Or one time somebody was, what did they say they took? The guy's like, I'm on like vitamin D. I take vitamin D shots or something. And I was like, no, he means like heavy medications. Anything you can't operate a car or heavy machinery with, all those things they tell you don't operate heavy machinery. You could hurt people. All those things. That's really what they're looking for. He says, I do not make the claim I was so drunk or under the influence of drugs or medicine. I didn't know what I was doing at the time of the crime. That's just him trying to, they're just heading off problems of the past. And you guys can see this is done through the Minnesota Supreme Court. This is a state level form. And the courts want to use this, they can, or they can modify it as they want. He also says, I do not make the claim I was acting in self-defense or merely protecting myself or others at the time of the crime. Pretty obvious. It's eliminating things he can do. He says, I was, and here you go, and he says, I was represented by an attorney, but he also is saying, I have not had a probable cause hearing. He says, I know that I could now move that the complaint against me be dismissed for lack of probable cause. I know that if I do not make such a motion and go ahead with entering my plea of guilty, I waive all right to object to the absence of a probable cause hearing. And if you waive that, it's done. By entering the plea, it's done. He says, I also know I waive all right to successfully object to any errors in the probable cause hearing when I enter my plea of guilty. So it's just an acknowledgement. When you enter plea, you really limit yourself to the plea for appeal purposes, guys, to the plea hearing and your sentencing. And he says, my attorneys told me a couple of things. The prosecutor has a case against me. The physical evidence I was obtained, evidence in the form of statements that I made or other people made, the evidence discovered as a result of my statements, identification evidence, if there's any out there, evidence the prosecution believes indicates I committed this offense. He's being discussed and told that he has, Aaron's also acknowledging my attorneys told me I have the right to a pretrial hearing before a judge should determine whether or not the evidence the prosecutor has could be used against me if I went to trial. Now, would that be a suppression? Well, that becomes more of a motion in limine, where the court has to make rulings on the admissibility of things. In some courts you go in front of, I've been in front of a judge, he was specific about this. He had hearings about pretrial admissibility of all exhibits. Now, obviously, if you were going to enter something like there's a change at the last minute or impeachment evidence, you don't have to discuss that. But in general, you would have pretrial admissibility hearings. So that does happen at times. And he says, if you requested such a pretrial hearing, I could testify at that hearing if I wanted to, but my testimony cannot be used as substantive evidence against me if I went to trial in this case. He says, I do not request such a pretrial hearing, and I specifically do now waive my right to have such a pretrial hearing. Also, chat, you could also argue if this was like a Frank's hearing, discussing some things, that might be factored in as well. But generally speaking, at a suppression or a motion in limine or any type of thing like that, you're not going to talk as a defendant. That would be absolutely insane. But it could happen, theoretically. It says that whether or not I've had such a hearing, I will not be able to object tomorrow or any other time to evidence that the prosecutor has. So I've been told my attorney and understand that if I wish to plead not guilty, I'm entitled to a trial by jury on the issue of guilt, and all jurors would have to agree unanimously I was guilty before the jury could find me guilty. That if I plead guilty, I will not have a trial by either a jury or by a judge. So no jury trial, no bench trial. And also, Chad, I will mention, guys, last week, I mentioned I was having that trial set for next Tuesday. we actually pled out. We got what we were looking for. We were holding out. And we came in yesterday, told them, hey, we're ready to go. And the prosecutor's like, how about we talk for a minute? And he's like, what do I got to do? And I told him, and he's like, give me a minute. And he ran down the hallway and come back like, all right, we'll do what you want. So I don't have trial next week. If there's other stuff we can cover, chat, we'll be working on that and through this weekend as well. So he says, that with knowledge of my right to trial on the issue of guilt, I now waive my right to a trial. And notice this whole thing about the trial, it's in its own section because it is so critical. Your right to trial is guaranteed to you in the 6th Amendment of the U.S. Constitution. This is such a big deal. It's got its own little provision. And in fact, here in Ohio, many judges will make you sign a written waiver acknowledging separately that you're waiving your right to trial, specifically just that right, because it is such a critical right that we have. Aaron also says, I've been told by my attorney and understand that if I wish to plead not guilty and have a trial by the jury or the judge, I would be presumed innocent until my guilt is proved beyond a reasonable doubt. That should be unless, because, until means it sounds like that's a fait accompli. I think it should be unless that my guilt is proved beyond a reasonable doubt. But I've been told by my attorney, and I understand that if I should plead not guilty and have a trial, the prosecutor would be required to have the witnesses testify against me in open court in my presence, the right to confrontation, and that I would have the right through my attorney to question them. Well, we already know two of those witnesses, Gino Bisconte and Keanu Thompson, weren't showing up. And it looked like the prosecutor wasn't wasted time on that. So it was just going to be Nick coming in and being, Aaron's the bad man. He ate my goo, ladies and gentlemen. And then I'm sure Kayla getting drug in there and being forced to talk about the disaster that Nick foisted upon them. I'm sure she's going to be thrilled to testify. But those would have been the witnesses. And he says that with knowledge of my right to have the prosecution's witness testify in open court, I waive that right. He also says that I'd be entitled to require any witnesses I think are favorable to me to appear and testify at my trial. And that's acknowledging you have the right of compulsory process, the right to subpoena witnesses and force them to be here by order of the court. And if they don't show up, having the court enforce that order against them. So just like Gino and Keanu, they were going to have a subpoena enforced upon them. Aaron would have the same right through his attorney to use court process to compel people to be there. I'm now waiving that. He says, I've been told by my attorney and understand that a person who has prior convictions or a prior conviction can be given a longer prison term because of this. And that's true. The more times you have charges, the more convictions you have, or if you've been to prison, the more prison numbers you have, your odds of getting screwed over go up and up and up and up and up and up. Even for the smallest thing, at some point, it's really bad no matter what. Now, he says the maximum penalty the court can impose for this crime is 1 year of imprisonment. If a minimum sentence required by statute, the court may impose a sentence of imprisonment of not less than 0 months. So it's anywhere from 0 days to 365 days, chat. So it could be no time. Now, we're not worried about the DUI or notice here that for felony driving while impaired, which it can be at times, most sex offenses, and notice we're talking about that, so this doesn't matter. X'd out. We're not talking about issues about conspiracy, aiding, advising, counseling. We're dealing with no conspiracy, no complicity. He does acknowledge my present probation or parole, if I'm on anything, could be revoked. And that's always a warning that this plea of guilty may result in a revocation of your probation somewhere. Now, normally the judge will say, I'm not in charge of that, so I don't know what they'll do. They say the prosecutor seeking an aggravated sentence. Nope. So saying, I've been told by my attorney and understand that my attorney has discussed this case with one of the prosecuting attorneys, and that my attorney and the prosecutor agreed that if I entered a plea, the prosecutor will do the following. And chat, I know people were like, Sean, how do you know this? Can you just believe Aaron? Here, this is just chat. This is where, I mean, we need to discuss this just for like half a second, because there's just something you guys need to understand. I know some people on Twitter were like really confused about this too when it came to things, but it's like, just tighten up on me for a second. Tighten up. We're gonna tighten up here. Maybe I can talk to other people and I know things. Maybe I have sources. Just the thought. Just the thought. Just think on that. Let it marinate for a minute. Let it marinate for a minute. Okay. It's not just the steel toe man. Not just the steel toe man. All right, chat. All right. William is like, he's gonna eat us. Thanks. All right. So moving back into this. Yes, people confide in me and I don't break fucking confidence. Imagine that. Somebody who not only purports to be a lawyer, but also I don't claim to be a shitbag. I'm not holding myself out as breaking confidence. I keep confidence. Funny how that works, huh? So notice, here is the total things here. Plead guilty to count 2, the gross misdemeanor. Like I kind of said that from the start is what he was probably looking at. No contact order with Kayla Ricada. It continues during probation. So how long is probation? Don't know. No restitution. No, Aaron does not have to refund her the cost of one KNU. Dismiss the remaining count. No executed jail. $50 fine. Pre-sentence investigation report. And domestic abuse investigation. So it's like, that's it. That's it, chat. Another win for the toe. If you listen quietly, you can hear it in the silence. It's like the Man of War song. There's the sound heard across the land. Bum, bum. It's heard across the sea. You'll only hear it if you listen with your heart and know Nick Ricada's screaming "Ree." I'm sure you can hear that. Or if you hear a thudding sound in the distance, that's Nick punching himself in the head. Probably. Oh, it keeps going though, chat. We're getting through all this, but it's important to cover this so you guys know what it is. That if the court does not approve this agreement, I have and that's the thing, guys. This is interesting because we don't have this in Ohio. You just in Ohio, you get acknowledged, hey, the judge could do whatever he wants. If the judge doesn't approve the agreement, I have a right to withdraw my plea and have a trial. Yeah, well, any testimony I've given concerning the guilty plea cannot be used against me unless I am charged with the crime of perjury based on the testimony. Now, why do they bring that up? Because the judge asked Aaron, well, why are you pleading guilty? Because I did the thing. I disseminated I non-consensually disseminated a nude picture. So notice that's a complete admission. The prosecutor could go, aha, he admitted to the offense. But if the court blows up the plea deal, that can't be used against him. He says, except for the agreement between my attorney and the prosecutor, he says, no one, including my attorney, police officer, prosecutor, judge, or any other person, has made promises to me, any member of my family, or in any of my friends or other persons in order to obtain a guilty plea from me. No one, including my attorney, police officer, prosecutor, has threatened me. And that's important because, have you been threatened? Have you been promised? No. And normally they also say, have you been promised anything other than this? Well, there you go. And he says, my attorney has told me that if I understand guys, also, I need to catch myself. I said something retarded. We need to go back, fix it. The judge doesn't approve the agreement. The judge will say, I'm not accepting the plea. Although the way this is phrased, it could be the way I'm going to just not accept the plea and sentence you. And you could say, well, I want to withdraw my plea. So, because if the judge just automatically says, I'm not accepting your plea, well, then there's no plea and you don't have to worry about anything because you have the right to withdraw your plea. So I interpreted this when I read it as if the judge sentences me outside of the plea agreement, I can withdraw my plea and go to trial, but we'll see. And he says, and my attorneys have told me my plea of guilty is not accepted by the court before I withdraw the plea, or if the plea is withdrawn by the court order on appeal or other review, meaning so an appellate court could get involved. I would then, and here's the thing that everybody has, if you withdraw your plea, you're standing trial on the original charges. And the prosecutor can proceed against you as just if there had been no plea of guilty and no plea agreement. and they proceed as though it never happened. My attorneys told me, and I understand that if my plea of guilty is accepted by the judge, I have the right to appeal. But that appeal I may make, claiming errors in those proceedings, probably would be useless and a waste of my time in the courts. Yes, and that's normally what happens, chat. And like if there's a minor thing the court didn't do right. So, for example, in Ohio, if you don't get advised of, if you're given a prison sentence, you're not advised of your PRC, post-release control, or other advisements. The appeals court could say, yeah, we read the transcript. You got to get resentenced. The court goes, okay, blah, 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 blah. And by the way, you have a probation note or parole notice. And I sentence you again to the same sentence. Have a nice day. So literally, it doesn't change anything. Generally, when people appeal a plea offer and they appeal a sentencing based on a plea, there's nothing to it. You end up having to file an Anders brief saying there's no actual grounds for an appeal. The court did everything correctly. So, and also, I think there's some people on the farms who are Minnesota attorneys who are, feel free to correct me at that last little bit too if I it up. Not Nick, like practicing Minnesota attorneys. My attorney has told me, and I understand a judge will not accept a plea of guilty for anyone who claims to be innocent. True. I now make no claim that I am innocent. I've been told by my attorney, and I understand that I wish to plead not guilty and have a jury trial. I could testify at trial if I wanted to, but could not be forced to testify. That if I decided not to testify, neither the prosecutor nor the judge could comment on the failure. Remember, that's your Fifth Amendment right to remain silent. That with the knowledge of my right not to testify, and that neither the judge nor the prosecutor could comment on it, I now waive and give up this right and will tell the judge about the facts of the crime. Oh my gosh, you guys sent so much crap down here. All right. He says, my attorneys told me, and I understand, that if I'm not a citizen of the United States, this plea of guilty could result in deportation, exclusion from admission to the United States of America, or denial of citizenship. Well, it depends. Depends on which district court judge you're in front of. I'm probably thinking some of them will prevent that. So in view of all the above facts, I wish to enter a guilty plea. This was today by Aaron Imholte. Did not include his address, and that is it. So Aaron's plea has been accepted. He's getting sentenced, I think, sometime in June, from what I've heard. There has not been an update to that. That is the only thing that's out there is a notice of a hearing. And the hearing is weird because it says, it's set for today. There was a hearing set for today, and that was it. So Aaron is done. He'll get sentenced. Looks like he's getting exactly what he said. Exactly what he said. Oh.